Hello, this is Matt on the Moon Lambo channel, and today was the big day. It's what we've been waiting for. The pre-trial court hearing, SEC attorneys and Ripple attorneys all actually present in court today. And I have to tell you, this was an absolute disaster for the SEC. I don't know that it could have gotten much worse. The judge had to cut off the SEC attorney who was speaking, cut her off. I don't know. I didn't take an actual tally, but it's probably at least 5 times. 5 or 6 times would be my best guess. When she's just talking, but she wasn't going anywhere. It didn't make sense. There were inconsistencies. And it seemed as though the judge, perhaps, while completely professional, maybe was a bit frustrated with this completely non sequitur logic. It didn't make a damn bit of sense. So I actually did attend the telephonic conference, or at least for me it was telephonic anyway. And I took some notes along the way. You're actually not allowed to record these things, which makes it difficult. But if you do, then that's actually a criminal offense. So don't do that, obviously. But I was furiously taking notes as I was going about this, and I even was able to get a few tweets out along the way. But I'm going to share with you effectively what was stated, but it is bad for the SEC. Now, for us XRP holders, it gets us that much closer to what should be done here, because what was discussed, it was really one topic, honestly, the whole thing. And this conference went on for over an hour. It started late and went on for about an hour and 10 minutes or so. It was really all about the attorney-client privilege issue. So you may recall that the SEC is claiming that Bill Hinman was a client of his coworkers, attorney-client privilege. And as a result, since Bill Hinman was a client of the SEC, even though he's also an employee there, which makes sense apparently to them, since that's the case, any emails associated with his with Bill Hinman's Ethereum free pass speech from June of 2018, any emails associated with that are privileged. You can't let those get out. That's attorney-client privilege, right? Now the problem is, as you'll see as we go through this, what actually happened here, it doesn't even almost meet the standard of attorney-client privilege. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And I also want to remind you, the reason that what I'm covering here is such a big deal, from my personal perspective here, is if the judge indeed finds that there was no attorney-client relationship here, there was no attorney-client privilege, then that does mean that, again, the SEC must hand over these emails that they don't want to hand over, and there must be exculpatory evidence then, because the SEC is fighting intensely, and they haven't fought this hard for anything else in the case to prevent this information from getting out so hard. It's just they're stretching reality to a point where it doesn't resemble anything like not even something with a semblance of something that can be recognizable by a human. Like it's wacky, it's bizarre there. So if indeed it goes the route that I believe it's going to go, they're still going to have to hand over these emails, and there's probably something in there, I'm willing to speculate, that would just ruin the case for them. So it is that big of a deal. Because if that's the case, they're not going to hand over the emails, even if demanded still, but there would be a settlement, I believe, anyway. That's my speculation here. So anyway, the judge began the conference by asking 2 very simple questions. And these questions allowed the SEC to basically hang itself. And it seems to me that the judge was expecting the answer that was given by the SEC attorney, based on what it had argued to this point regarding the SEC bogus claims of attorney-client privilege. And unfortunately, I couldn't catch the SEC attorney's name. It was not Jorge Tenrero, who is the one that we normally hear from these pre-trial hearings, and also on a lot of the legal stuff that's been filed. There was a woman who was representing the SEC today, so I'm sorry, I don't know what the attorney's name is. I couldn't quite catch that, but it is what it is. Anyway, the judge asked what legal advice you are arguing Director Hinman received, and what was the purpose of that advice. Those are 2 questions. So again, what legal advice did Hinman receive, and what was the purpose of that advice? And you'll see why this is important as I go through this. So the SEC attorney seemed ill-equipped to answer these questions coherently, and her answer was that, quote, "the speech was very legal," end quote. At this point, the judge cut off the attorney and said, quote, "The speech was very legal. Did I hear that right?" End quote. So that's the first time where she got cut off. And mind you, it's probably only like, I'm guessing 2 or 3 minutes into this going on. Already got your first cutoff right there. And so at this point, the judge, I'm sorry, at this point, the SEC attorney responded with, quote, "Yes, Your Honor," end quote. So there we go. Think about what's being said here. The Hinman speech, just his personal opinion, but it's also very legal. What does that mean? It's a legal personal opinion? And so she said, "Yes, Your Honor," and then proceeded to state that the legal advice was on the nature of how securities laws apply to digital assets. The SEC attorney stated the purpose of the legal advice Hinman received was to make sure that his speech would not be inconsistent with the SEC's approach to securities law application to digital assets. So the SEC attorney then stated that Hinman needed to educate himself about how SEC laws apply to digital currencies, as if he didn't already know. In fact, later on, Ripple's attorney, Matthew Solomon, would rip that idea to shreds, citing evidence, actually, that of course Hinman understood the Howey test prior to allegedly seeking legal advice from his SEC coworkers, and he cited some specific examples, in fact. And so Judge Knepper then said, and this is a quote, "Here's where I'm having a hang-up," end quote, and then said, "Lawyers for the SEC are lawyers for the SEC, which is to say the SEC is the client," end quote. Now think about that. She just said, again, SEC lawyers are the client. So Judge Knepper just said the SEC is the client, and if that's true, then Hinman can't be the client. So he has no attorney-client privilege. And a couple minutes later, Judge Knepper then cut off the SEC attorney mid-sentence for the second time to point out a very clear contradiction. She pointed out that last year, the SEC was arguing Hinman's speech, it's just his personal opinion, right? Yet today, at this conference, the SEC was now arguing that the speech was based on the official position of the Corporation Finance Division of the SEC. And the SEC attorney said that multiple times. And Judge Knepper, she's just taken aback by this. It's like, I could just imagine, I don't know for sure what's in her mind, but it just seemed to me like stunned disbelief. Just like the rest of us would take this. Because you're clearly talking out of both sides of your mouth at this point. Oh, it's his personal opinion, but it's also the official position of Corporation Finance. The same stuff that I've been highlighting on this channel and we've been talking about in the community as a whole for a long time now, just how absurd this is. Well, like I said, I've said this many times, anybody with half a brain, if you're unbiased and you just see this, you're going to come to the same conclusion as that the SEC just doesn't make any damn sense. And so I said I'd be shocked if the judge here, Judge Knepper, didn't come to the same conclusion. It's very clear she has come to the same conclusion as the rest of us. It does not make sense. It is not coherent. And it is stupid. S-T-O-O-P-I-D, stupid. So, not long after that, Judge Knepper said, quote, "We're talking about this speech in different lights, depending on how it suits the SEC," end quote. Which is a very clear slam against the SEC. It's the same thing. Whatever suits the SEC in the moment. We've been saying that within the XRP community forever. And there the judge said it to the SEC attorney's face, in person. Again, the quote, "We're talking about this speech in different lights depending on how it suits the SEC." Folks, she's not, she's seeing through everything the SEC's thrown out here. Because the SEC arguments, they are that bad. It's astonishing stuff here. Absolutely astonishing. Now, Ripple attorney Matthew Solomon then had an opportunity to speak. And he expressed the same concerns that Judge Knepper highlighted and noted the same inconsistencies in the SEC position that the judge pointed out. This was also the point in time where it became clear, very clear, why Judge Knepper started the conference by asking those two simple questions, which are, again, what legal advice did Hinman receive and what was the purpose of the advice? So now we're coming full circle here. And this is important because the judge pointed out that the purpose of the legal advice must be to conduct agency business, or else there is a, quote, break in the chain, end quote, meaning it's not attorney-client privilege. Now, given that, as the judge pointed out, the SEC has already argued that the Hinman speech was just personal opinion. It cannot then have also been to conduct agency business, which again is a requirement for there to have been the existence of attorney-client privilege. It can't be both ways, right? And so as a result, obviously, there was no attorney-client privilege between Hinman and his fellow SEC coworkers. The logic simply doesn't follow. In fact, Judge Knepper said, quote, did Hinman's June 2018 speech represent the official position of CorpFins, end quote, so that'd be corporation finance. And the SEC attorney responded, yes. Just responded yes. So there are clear inconsistencies here, very clear inconsistencies. And, in the later part of the conference, Judge Knepper even point blank asked the SEC attorney if she thinks their position has been consistent. And she said yes. But the judge absolutely did not believe that, obviously. But if you're at the point where the judge is saying, do you think you're being consistent in your positions here? I tell you, you've got the judge asking you that question, you done messed up, son. Like that's clearly an indication that things not going so hot here. And the whole conference, the whole thing was on this topic, the whole thing. And it was just the SEC attorney spending a lot of time spouting the same inconsistencies, and eventually, why did the conference wrap up? Well, Judge Knepper didn't ever get an actual good answer that was coherent. It's because it had gone around in circles enough for long enough time where the judge was clear, like, okay, well, this is not going anywhere, and then that's when it wrapped up. But there seriously never got to the point where it's like, oh, I see the logic of which. No, nothing even close to that. Not even freaking close. Oh, it was really entertaining, though. Seriously. I couldn't believe this stuff here. And so I put out like several tweets. I was already having, most of the time I was just sitting there like diligently listening and taking notes, but there were parts where the SEC attorney was just repeating herself so much. I was like, okay, I think I get a few tweets out here too. So I put out like several tweets or so. But wow, it was truly, truly stunning here. And then XRP community member and attorney Fred Rispoli responded to my post about the call, which was public, by the way. And by the way, it would also maxed out. My understanding is there's 4,000 spots available. It was maxed out, according to one person's account, by 3:02 p.m. It was originally supposed to start at 3, and then they were late. It didn't start until almost 40 minutes after that, actually. But think about that. So they open up the lines about 15 minutes prior, so that would have been 2:45 p.m. Eastern Standard Time. And then by 3:02 Eastern Standard Time, 4,000 XRP holders sitting in there, including me. It's astonishing, the amount of attention around this case. But anyway, attorney Rispoli responded to me and wrote, I will be doing an Action Jackson head bob, counterclockwise, just like my man RJ, every time Judge Knepper calls out the SEC attorneys in any way. Hope I get unnecessarily dizzy for this one. Oh yes, well, if you did what you said you were going to do, Mr. Rispoli, then you got dizzy because it was a complete bleep show. And so I responded to him and wrote, it was really incredible how many times the judge tried to get the SEC attorney to clarify their position and how many times she had to stop the SEC attorney mid-sentence because what was being said didn't make sense to the judge. And then there was this from attorney Rispoli in a separate tweet. He said, SEC suffered an epic beatdown at this hearing for those who couldn't get in. I hope the attorney for the SEC realized her arguments were toast walking in as opposed to actually believing them. Yeah, well, I'll say this. I don't think that the SEC attorneys believe a lot of the stuff that they're saying, including this argument with attorney-client privilege. I don't believe it. Absolute toast here. And then there's this tweet from John Deaton's Crypto Law, which was retweeted by Eleanor Terrett, who is a journalist at Fox Business Network. But here's a tweet from John Deaton's Crypto Law. Netburn recalls during the fight over deposing Hinman, the SEC argued he wasn't speaking in his capacity as director of CorpFin. The SEC's counsel is stammering, then says Hinman was giving advice to the market. Yes, folks, that is indeed true. The SEC attorney said that Bill Hinman's speech, which they have argued is his personal opinion, that it was advice to the market. The SEC attorney said that. It's advice to the market. I think not only did the judge not buy the crap that you were saying, you just made things that much worse. My God, it's absolutely astonishing. And then there was this, also from John Deaton's crypto law organization. NetBurn, because they did a great job going through and live streaming, or live tweeting rather, what was happening, and it's a very long thread, but that's where this comes from. I thought I'd mention it anyway. NetBurn has just hit her first serious blow, accusing the SEC of changing its position just to suit their whims, and sarcastically asked them to, quote, pull up the speech and show which part is the SEC and which part is personal views, end quote. Now that was an astonishing part right there. Think about that, because again, they're saying that it's the official position of corporation finance, but it's Bill Hinman's personal opinion. So the judge is like, okay, pull up the speech and tell me which parts are just the personal opinion and which parts are official SEC Division of Corporation Finance position. Like, what the hell does that even mean, right? And then NetBurn asks the SEC if it is now taking the position that the speech reflects the views of CorpFin. She has to ask twice. The SEC says yes. And then there was, I think I might have one more here. Judge NetBurn said, I don't understand the caveat. If the speech was given from corporation finance, then anyone could have given it. But Hinman gave it, and it's his views. Every time I ask you if it's CorpFin's views, you say it was his. So think about this. If it's just Bill Hinman's opinion, only he can give that speech. If it's CorpFin's, Corporation Finance Division's position, then anybody could have given it, right? And so that's why she keeps trying to get this SEC attorney, this little asshat, to just say which parts are which. You can't do it, though, because it's logically inconsistent. And so after an hour and 10 minutes of this, that's when finally the judge basically threw up her hands and was like, okay, well, I guess that's enough. That's what it seemed like to me, anyway. Crazy, crazy stuff here. This is not going to go well. So I don't know when the ruling's going to come down. She ended up concluding the conference today by saying, I'll get it out as soon as I can. So who knows, maybe it's a week, maybe it's two. But it's a virtual certainty. This is going to be a win for our side. It's going to be a win. Let me know what you think in the comment section below. How many out there were listening in when I was? I'm sure a lot of you were. I'll go ahead and wrap up here, though. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.